All right. Okay. Now we are starting on. We had already started on consideration. Okay. Now, just to set the context, why are we interested in consideration? Because if you remember that when we started looking at Section 2, which they have called the interpretation clause. Okay, when we started looking at contract was an agreement forcible by law. So what was an agreement? An agreement was, in defining an agreement, they had used two new terms, promise and consideration. And so we took the first of those two new terms, promise, and we started breaking it down further, down to its atomic level components. Promise was basically a proposal that was accepted. Still not good enough, because proposal is a technical term. What does it mean? Then we look at a proposal, and then finally proposal has been drilled down to a kind of a atomic level component where it's in plain and simple language and does not contain any big term that needs to be further explained. All right. So here you see that so here I've used a term called atomic level construct. Okay, so let me explain what that means. This is a part of your English writing. Okay, so lab is meant to develop all kinds of skills, and one of those, of course, is English comprehension, English writing, spoken English, etc. Okay, now let me just take to okay. So this is a style of writing, atomic level construct. What do we mean by that? It's a construct which can't be broken down further. Okay, so this comes from the idea of the atom, which earlier used to be the lowest level of matter, I guess. Okay, I'm not a physics student, but then of course we have now we have quantum physics, which is the physics of subatomic particles. So this kind of language actually came about. It predates quantum physics. So at that time, atomic level was indeed you couldn't break down an atom further. But even after quantum physics has come onto the scene, which is many years now, but this language has not changed. Okay, so we still say atomic level construct, by which we mean that it's a construct which is at the very basic level and can't be broken down further. So to give you an example, if you take a room as atomic level construct, okay, and then you think of an apartment as a aggregation of rooms, a set of rooms, then you can actually start, if you're going up, then, or you can start from the very top. Okay, you can start with the universe, then you can come down one level, look at the galaxies, I guess. Then under that you can look at the solar system. Then under that you can look at all the planets, and you can look at planet Earth. Then under planet Earth you can look at Asia. Under Asia you can further look at India. At all the countries you can look at India. Under India you can further look at New Delhi. Under New Delhi you can further look at Pitampura. Under Pitampura, you can further look at, let's say, Professor Atul's house. And in that house, you can see further that there are 4 rooms, okay? And then, so therefore, and you can come down to the lowest level, you come down to the room. Once you come down to a room level, you can't break it down anymore. And so now you're at an atomic level. So this is what is meant by atomic level. So this is what is meant by disaggregating something down to the atomic level. So which is what we did in the case of the definition of an agreement, of a contract, because we started with contract and then they told us it was an agreement. And we needed to disaggregate, we needed to further decompose this. Then in decomposing that, we came up with these two. We had to decompose these two. Then finally, we got to decompose promise down to a level like proposal, where it is in plain and simple language. So it is kind of like an atomic level construct, which does not need to be or can't be broken down further or can't be simplified further. Okay? But we also have to deal with another concept that was given to us when we talked about we discussed what an agreement was, which is that what is an agreement? Set of promises, one side, set of promises on the other side, forming the consideration for each other. Okay, every promise, set of promises, forming consideration for each other. Okay, so this word was used, consideration. So what is consideration? And that's why we are today looking at consideration. Okay, or we looked at the other day as well. Okay, so just to set the context, just to as we start the class, we start a new class. Why are we interested in consideration? Because of this. Okay. So here we had already looked at this kind of a breakdown. Now this, if you see the actual language of the Contract Act, it does not contain all these stars and all that. Okay, so this I've just put in because I wanted to break down the section for you to make it easier to understand. Sometimes you may find even uh, longer sections than this, so it becomes very difficult to understand. And that's when you should actually break it down into these parts. And so when we do this, the language that we use in the law is we say these are the ingredients of the section. So when your mother's making cake, you have flour as one of the ingredients. If you're making a classical cake, then you'll have eggs in it, and then you'll have cream, maybe whatever, some kind of sugar, okay, all kinds of stuff. So those are all the ingredients of the cake. Similarly, we say in the law, we use the expression, the ingredients of the section, okay. So here we have the ingredients of section 2D, okay, consideration. So when we say, what is basically happening here, I'll give you the overall scheme and then you can read, because the language itself may not be very friendly. So you have essentially the promisee. Okay, remember who the promisee is? If you go back, promisee is the person who accepts the proposal. What did it say? According to the language of the Act, the person accepting the proposal is the promisee. Okay, the person making the proposal is the promisor. Okay, the person making the proposal. Okay, now you see here what is happening. The promisee. Okay, we can come to this a little later. So there is at least the promisee or any other person. Okay, so these are the two people who are acting. Okay, and what are they doing? They're doing or abstaining from doing. So this you have to remember that in the law, when we say generally when we say act, it includes the idea of does not act. Okay, so act or omission. Okay, the IPC also you'll see anywhere, pretty much everywhere in the law, there is this common idea that when you say act, it includes omission, okay, not acting, failure to act. So therefore I'm not going to mention done or abstain from doing, because it is understood that when I say done, it includes the idea of abstain from doing. So to make it simpler, I'm going to just say done. Okay, so this entire section from here to here is actually just the same thing, which is done. Okay, but it's about doing. It's about doing, but it's in three different tenses. So there's past tense here, there is present tense here, okay, and kind of like present tense, okay, and there is future tense here. Okay, you can think of it this way, but it's actually just the same thing, which is the idea of doing something, which includes the idea of not doing something. Who is doing or not doing? The promisee or any other person. Okay, and what are they doing? Something which what kind of something is that? Okay, what kind of something is that? Which is what kind of something is that? Is it something that these two guys just, any of these guys just kind of, let's just take the promisee to simplify matters. That's something which the promisee does. Is it just something that the promisee dreams up, wakes up in the morning and says, okay, let's do this, okay, and will that form consideration? The answer is no, because there is this other part here, the desire of the promiser, okay? And remember, in order to be called a promiser, you must have made a proposal, okay? That's why you're called a promiser. So there are two things happening here. Actually, a promiser is making a proposal, okay? A person is making a proposal, and thereby he's becoming a promiser, okay? That's the first step. Now, the second step is the promiser is also expressing a desire, okay? He's expressing a desire that the promisee, okay, or the promisee has to either have done something or do something now or promise to do something in the future, okay, has to do something. We'll just call it do something in three different tenses, past, present, and future. So the promiser first, a person makes a promise and makes a proposal and becomes a promiser, and then expresses a desire that the promisee, that the person who will accept the proposal, should do something. Okay, so not something that this guy thinks of independently, but something which this guy wants. He wants this guy to do. Okay, something. Okay, that's what is basically consideration. Okay, so and then such act, absolute promise, is called consideration for the promise. Which promise? this actually. Well, again, this language is not correct actually. The language of the act. But anyway, once the proposal, if you have said promisee, it includes the idea that the promise has been accepted, the proposal has been accepted. Because again, I objected to the word promise. Actually, I would have preferred proposal because uh, the person making the proposal is the promiser, okay? And he's not making a promise because the promise is only when the proposal is accepted, okay? So, but it's okay. Small, this they have not been very strict about this in the language of the act. But which promise is consideration for which promise? It's the consideration for this promise, this guy's promise, which is actually his proposal. And we are assuming it gets accepted because we have called the other guy the promisee. He can only be a promisee if he has accepted the proposal. Okay, now this is my language. Okay, uh, but the Contract Act language is person accepting the proposal is the promisee. Okay, so therefore, right here you have this. Okay, so there is basically a consideration for the promise. Which promise? It is the promise of made by the promiser, after which he expresses a desire that the promisee who accepts the promise made by this guy will do something specific. Okay? And so this is basically that thing that this person does is the consideration for this guy's promise. Okay, so you have to understand this. You've got these two actors over here. Okay, and this guy has already made a proposal. Okay, which they have now called a promise because we are assuming being a promisee, he has accepted the proposal, that it turns into a promise. And that's the promise that is being referred to here, the promise made by this guy. Okay. And what is the consideration for the promise? The consideration is whatever this guy does at the desire of the person making the promise. That is the promise. Okay. So to put this into concrete terms, okay, let's go back to our example of the gardening proposal, right? So if I go and tell an old lady that I know that she can't afford to do the garden herself, it's too old. So I tell her that I will take care of her garden, do her gardening. I'll do it 3 days a week. Okay. So I am making a proposal. I am proposing that I will take care of her garden 3 days a week. And so I am therefore the promiser. Okay. And while I make that proposal, I'm also expressing a desire, okay, to the old lady who is going to become the promisee once she accepts my proposal, that you should promise to pay me $100 a week. Okay, so this $100 a week did not come out of her head; it came out of my head here. So I'm saying that, okay, I'm making this proposal and I would desire that you make a promise to pay me $100 a week. Okay. So in this case, this $100 a week will become the consideration flowing from her side. This is the way we can use the language. That this will become the consideration flowing from her side to me, and from my side to her side, the consideration that will be flowing is the actual service that I'll be performing in doing her garden 3 days a week. 3 days a week, right? So there are two considerations here. You have to understand. There are two considerations in any bilateral contract, completed bilateral contract, a validly completed bilateral contract. There is a consideration flowing from one side, from here to here, and one from here to here. You can call me the promiser here, but actually, if you look at it from the lady's side, she is the promiser when she promises to do this. Okay, promises to pay $100 a week, and the consideration that I have, she desires that, because there's obviously a bargaining process that goes on. So it depends on whose side you look at it from. So you can actually you can easily have see two considerations, two promisers and two promisees. View that from her side. If she's making the proposal first, she's saying, please, do the garden 3 days a week. I'm promising, I propose to pay you $100 a week, and I desire that you should either do or promise to do my garden 3 days a week. Okay? So there is basically, it depends on which side you look at it. It can be both. Okay, I mean, so there'll be two considerations. Okay, so this is basically what this is. Now I think you understand this a little better. Okay, so this is basically what consideration is. All right. Now I'll just talk about briefly the idea of where did I write all that actually? There was yeah. So in the case of contract, okay, in the case of consideration, let's go here a little bit, and then we'll come to this discussion about which we had in the other class, which I think is an important discussion. Right? Let's look at consideration, because there was a question about Harsh asked a question about any other person, okay, and that led to a long discussion. So that is what that's what I like about these live classes, where a student asks a question and it takes the discussion in a particular direction. Not entirely irrelevant, because obviously connected, everything is connected to contract law. But if he had not asked the question, I may not have gone into all these discussions. Okay? So that's why we come to class, really, because if in an ideal world, all the videos will be released as lectures, at the end of the class. So you don't need to come to listen to the lecture, but you do need to come to ask questions. Otherwise, you can't ask questions. So now, anyway, so here we are. What we are trying to explain in further examples of consideration. So if I go to a Starbucks and I buy whatever, mocha frappuccino or whatever, I give them 400 rupees. Okay. So I am the promisor in this case. Okay, I promise to give you, or I am giving you. Okay, I propose that I will give you 400 rupees, and I express a desire to the barista, who is the promisee, that she should, or maybe you're paying at the counter first. You're talking to the cashier. Okay, then I tell the cashier that I would like you to give me, or promise to give me, a mocha frappuccino or whatever. Okay? So a coffee. This is how it works. So in this case, we say that the consideration is any kind of market exchange, a good or service. A good means, okay, not good and bad, but good as in sale of goods act. Okay? So any kind of, so generally what we define as market exchanges. Okay, when you come to finance, you'll see. When I define a market, I will define a market as a value for exchanging goods and services for money. Okay. So a market becomes a venue where you exchange goods and services for money. So if you go to the Gazipur vegetable market, okay, so that's an example of a market, because there are lots of goods and services. Well, not really services; those are more mainly goods. Goods are being exchanged for money. You can see this in any market. And so here both are consideration. Okay, so if I go and buy 100 kilos of potatoes from the Gazipur market, the consideration that is flowing from me to the potato seller is the money for the transaction, the total amount of money that is. And the consideration flowing from the potato seller to me is those 100 kilos of potatoes. He has to deliver that to me. He has to promise to deliver me those potatoes. Okay, and in return, I promise to pay him, or I actually paid him the amount of money that he requires. Okay, so this is a simple example of. So you look at any kind of market exchange, you can think of it, and you can say it this way: that the consideration flowing from me to Starbucks is 400 rupees, and the consideration flowing from Starbucks to me is the coffee. Okay, so this is how you would say it. The same with the case of the market exchange. Okay? Now, there is a less obvious form of consideration, okay, which is you might have certain types of agreements where the particular payment there is no explicit payment being made, okay, or there is no explicit item that is being handed over as consideration, like a cup of coffee or 100 kilos of potatoes or things like that. You can't really identify anything tangible, okay? But there could still be an agreement, okay? Remember, because Without consideration, there will not be an agreement. We'll come to that. Okay, in general, there is agreements without considerations. Okay, we call them Nulum Pactum. We'll get to that in common law countries. So that's why we are so concerned with understanding consideration, because this is a very important aspect of contracting in a common law jurisdiction. So remember, in Italy, this is not important because in Italy, it's a civil law country. They are not hung up on consideration. In Italy, you can make a contract without consideration and you can still enforce it. But you can't do that in the UK or India and places like that, okay, which are common law countries. So we want to understand more. We want to have a very comprehensive understanding of consideration, okay, which is that let's understand less obvious types of consideration. Okay, less obvious forms of consideration. Okay. So now, if we make an agreement, let's say I make an agreement with anybody in this class. Okay, so I make an agreement with Aditya. Okay, where I say that we are doing a redesign of the finance lab. So if you stay back to let's say that there's a big excursion happening to a smartphone factory, and every student who goes there would be given a free smartphone. Okay? But you actually have to go there. Okay? You can't just get it by sitting on the campus. So everybody's about to go there, but then I tell Aditya that if you stay back and help me with the redesign of the finance lab, we will give you a special certificate and a special award and all that as a student who has contributed to the lab, etc. All this stuff, a special certificate. Okay, so Aditya thinks that this special certificate is a very big deal. So he decides that, okay, I will give up the idea of this, the possibility of getting the free smartphone, which is guaranteed actually if you go there. Then he decides to stay back and help me with this redesign, etc. But there isn't, let's say, a lot of heavy work involved as such. Maybe he's just sitting in some place and I'm just asking him from time to time. Maybe he's sitting in the library and watching a live feed of the lab. And I'm just asking him, can you see this? And he says, yes, okay, can you see that, etc. So it's not much work actually. And when you look at him, it looks like he's not really doing anything. He's just sitting in the library. So, here what happens is, so let's say this happens. So there is an agreement that we are saying on the face of it. Let's see if it's an agreement or not. Okay, there will have to be consideration in order to be an agreement. So what happens is, both of us think that we are entering into an agreement. Okay, or at least Aditya thinks that he is entering into an agreement, but enforceable agreement as well. Okay, so he. Therefore, what happens is this happens. So he stays back and then he helps me out with all this feedback when I ask him about whether he can see and see this and that. And then after all that is over, after a few months, when Aditya is asking, so could you give me your give me the certificate? I said no. I say that no, we won't give you any certificate. Okay. So now I said there was no consideration. We were just sitting there. You didn't really do anything. So you were just sitting there, and there's no agreement. There's no no question of a contract, and we are not going to give you any certificate. So in that case, what happens is that if there is if he goes to court on this, what happens? We are just imagining all this, but there is actually consideration. His lawyer can argue that there is consideration in this case because there is a detriment that Aditya suffered. There is a sacrifice that he made. It's not obvious. You see him that he's just sitting there in the afternoon in the library, and once in a while he say, okay, yeah, I can see this, I can see that. So it doesn't seem like he's really doing anything, but there is actually something we have forgotten, that by staying back and giving feedback from the library, okay, and not going to the trip to the smartphone factory, he has given up on a free smartphone, which has a certain monetary value, right? So in this case, now, why did he give it up? Remember also one more thing. What has he done? Who asked him to sit in the library and keep responding to a live feed, answering questions? I asked him, okay? And what did I propose? I proposed that I would give him a special certificate, okay? I was the professor, I proposed that. And I also proposed that after making the proposal that I will give him a special certificate, okay? What did I, so after making the proposal that I'll be giving a special certificate, what kind of desire did I express? I expressed a desire that he should not go to the smartphone factory trip. Shouldn't go on that trip. with the rest of his batchmates, but he should rather sit in the library and respond to my questions. Okay, can you see this? Can you see that? Give me feedback, and be there in the library. So the fact that he was sitting in the library there, it's not something that he wanted to do, but he was tempted by the offer of the certificate, and I wanted him to sit in the library. So that thing that he did, and I wanted him to not go to the smartphone factory and therefore also get the free smartphone. I wanted him to do that. So therefore, because I wanted him to do that, and because in return I was promising him a certificate which he valued he placed a high value on the certificate. Okay. Therefore, and that's the only reason he did this. Otherwise, if I had not made this kind of a promise, he would have joined his buddies on the trip to the factory, right? So he misses out on the enjoyment of the trip. He misses out on the free smartphone. So here we say that yes, we would say that no, there is still consideration that has flowed from Aditya's side, because he gave up something, he sacrificed something, the enjoyment of the trip, the free smartphone, and so in that sense he has suffered some kind of detriment. Detriment has the sense of some kind of loss, okay, or a reduction. Okay, so you can think of it as kind of like opposed to increment. Increment, you get so they're not really exactly opposite, but they sound very kind of like similar, and they have the opposite sense. In increment, there's a sense of increase, okay, and in detriment, there is a sense of decrease, okay, of loss or decrease or reduction, and generally reduction of utility is what we would say in economics terms. So therefore, one of the things to look out for is, and we'll do some cases on this, that consideration doesn't always have to be as obvious as by going to the Starbucks store. Am I going to Starbucks and my mocha frappuccino is the consideration flowing from Starbucks, and the 400 rupees is the consideration flowing from me? Those are very obvious, okay? But it will not always be so obvious. In this case, that example that I gave you, maybe it's a little bit of a contrived example. But the idea I was trying to bring out is that even though Aditya has not done any big work, like he was not shoveling dirt in the garden or something like that, physical work, but he was just sitting there and just giving some responses. It seems like he's not doing anything, but he did do anything. He did do something because he gave up. By sitting there, he gave up the factory trip, and therefore he gave up the smartphone, and therefore there is a sense of sacrifice involved. And he would not have done this had I not made this promise of giving him a certificate. So this is important to understand, that the person gives up something in a very broad way. So if you define consideration in this very broad way, if you think of it in this very, very broad way, you can think of when I give the money to Starbucks for my coffee, you can think that I am suffering this detriment or loss because this money is now no longer in my wallet. So I am poorer by 400 rupees. So this is a sort of detriment also. I have sacrificed. So I prefer generally that you think of this very broad definition, and this broad definition or broad idea of detriment is so broad that it can even capture the more specific, more obvious and tangible forms of consideration, where you are buying potatoes for money, or buying coffee for money, okay, or paying the plumber to fix a broken kitchen sink. Okay, these are all examples where fixing the kitchen sink is the consideration flowing from the plumber. That's a service, and the money you pay to him is the consideration flowing from you. These are very obvious, but you can also fit these into the broader definition of detriment, because every time that poor plumber who is having to go and sit through all water splashing into his face and fix the kitchen sink, all that hard work that he has to do, okay, that hard work, and also the you can think of the expertise that he has paid money to acquire, okay, how to fix pipes, etc. All those, the money spent on that expertise, you can think of a depreciation of that amount of money. All that those are the detriments that he's suffering. Okay, and in return you're paying him the money, and when you pay him the money, that is a detriment for you because you are sacrificing that money. You are poorer by that much. Okay, in this case, Aditya was poorer by the amount of the smartphone and the other enjoyment, the non-intangible enjoyment of the trip. Okay. So this is the idea of consideration. Get a broader idea of consideration. We will see this in some of these, some of the cases that we will do later on consideration. Okay. So this is the idea of consideration. Now let's go to the next point, which some of these points. Yes, Soumya?
Huh?
Yeah,
So this since consideration is such a broad term,
yeah.
there can be situations where where the consideration that is rendered is unfair or unjust. Is there some mechanism through which we are keeping a tab on that as well, or through which that can be checked or questioned in court?
So what Soumya is raising is actually another interesting point. She's talking about adequacy of consideration. Okay, all right. So adequacy of what she's saying when she's saying unfair or unjust. What she's saying is that okay, if Starbucks charge me only 15 rupees for the mocha frappuccino, maybe that amount of money is not a fair compensation for what goes into the making of the mocha frappuccino. So she's raising this question: is it unfair, unjust, inadequate? All these. Now you realize these are all normative assessments. Okay, these are all normative assessments. So this is a fundamentally normative question. Okay. So generally what we do, the general idea is that this in contract law, okay, we don't normally uh, so we tend to be formalistic in our approach and therefore and thus not uh, well that is not and thus are not and thus let's say avoid normative uh, avoid getting into normative debates. Now, if you see adequacy, you're not getting into normative debates. Now, this, if you see your question that you're asking is actually also tied to the minimum wage discussion that we had the other day. Okay, because a wage is a consideration. Factory worker working, maybe 20 days a week and toiling in the factory, and then he's getting a wage. But you can always say for any kind of salary, and you can look at any kind of salary and say, because it's a normative assessment, you can always say this salary is not good enough. Okay, you can look at Satya Nadella's salary as CEO of Microsoft and say, well, I don't think this is good enough. Okay, and no one can prove that you're wrong. Okay, so adequacy of consideration it's a valid question, no doubt about it. But you have to understand that this is a normative kind of perspective. That is this consideration adequate? This is a normative perspective. So in general, in contract law, if you have to understand contract law and the evolution of English contract law, which is basically what we are doing in this country also, this is basically, it's meant to facilitate the wheels of trade. Okay, if you remember how the English became such a tiny nation, became a global superpower in those days, in the pre-war days. Okay, and the sun would never set on the British Empire. How did they achieve that kind of dominance? Mainly through trade, and of course, then they had a killer navy as well. So, but mainly it all started through trade. So they are superlative traders, and the English contract law and English business law in general has also facilitated this, growth of prosperity through trade by being very, very formalistic in the in how they adjudicate or dispute. So English courts, English commercial courts will generally not not interfere with terms of contract. So if you agreed to agreed to do a certain if you agreed to supply certain maybe soft drinks at my party for a certain price, the court is not, and then we then there's some kind of dispute later on about the contract, and the court is not going to ask questions about, well, Somya was offered a very low price. That's not their concern. The point that they will see is that Somya signed on the dotted line and agreed to accept that low price for the soft drink she was supplying. And that's it. She's an adult. She's competent to contract. She signed on to it, and now she should live with it. So generally, this is the philosophy that the English commercial courts have brought into their jurisprudence for hundreds of years, actually. And this is also, you have to understand that. So in our country, Many people would say, no, this is a very heartless approach and all that. But what we can, that's why we are not, that's why we did not become what England became, right? A colossal global superpower in those days, okay? So, and a tiny country, if you look at the country, it's got a pretty tiny country. So, how did they become? By all these kinds of rules and the culture of English commercial courts, that they don't get into this business of is this fair or not fair. You signed on it. Now you live with it. Okay. So this is the attitude that the commercial courts take especially in areas like contract law, which is heavy. Because if you start getting into these kinds of issues, okay, these are kinds of the whole minimum wage debate, okay, the minimum wage debate, like is this a living wage? Is this a living wage? Now then you have the other type of debate in tax related matters, that are they paying a fair share of their tax? Well, are they paying the tax rate that is there on the law, on the tax statutes? If they're paying the tax rate, then where is the question of whether it's a fair share or not? They're not evading tax, right? They're in compliance with the law. Now, if you think the tax rate is not high enough, you change the tax rate. The legislature should change the tax rate. But no, nowadays you have a lot of these people, even in the UK actually. I saw this interesting debate, not debate, actually a hearing in the UK Parliament about with the Google finance manager. So there's this MP or somebody, she's telling the Google's finance manager, does Google pay, you think Google is paying a fair share of tax? So the Google finance manager is saying exactly what I'm saying. He's saying that, ma'am, we pay what is required by law. Now, what do you want us to do? You want to increase the rate? You increase the rate, then we'll pay whatever the higher rate is. What is the point of making a statement like, is this a fair share? You're a lawmaker. If you think it's not fair, you increase the rate. So these are all the kinds of policy-related disputes, okay? So the adequacy of consideration is a broad answer. Of course, I've given a very long answer to Soumya's question. But long answers are important because you guys are just getting into the into the domains. It's very important for you to understand all the different nuances and areas that are touched upon by this question, that are touched by this question. So therefore, I'll always give very long answers because I want to make sure that you see all the connections. Okay. So so does that give you some kind of clarity, Soumya?
I understand that there can be some some gray areas in this, but there can also be situations where there's gross wrong being done to the promisee just for the name of consideration, or there can be parties which will seek shelter under this. So by saying that it's normative or maybe not the right kind of thing that we should be getting into, it can still harm parties involved. So, for example, the debate that you're talking about, I remember seeing it for US. I think it was some MP named Miss Cortez who has raised this question.
Yeah, that's
And
Cortez. That's in the US. No, I was talking about a debate in the UK Parliament with the Google finance manager. Not a debate, actually, a Q&A kind of thing.
right.
Yeah.
So that can also, that is a case where they are doing wrong. So how are we taking care of that? As in the answer is just that the lawmakers should be, more cognizant of these things while making law. Is that it?
Yeah.
Or there can something else be done, or is there something in law that can help them?
No, see, the law is made by the lawmakers, right? So the legislature makes the law. So the legislature makes the law. So if they feel that the law is unjust, or the tax rate should be 95% when it is actually 35%, then they should change the law and make it 95%. So that's basically so answer to your question. I can bring in another element of that. What you're talking about also is that we'll come to this in a few, hopefully in a couple of sessions, okay, within the next session itself. That's when we get into the question of how do we know that an agreement is a contract, okay? An agreement has to pass certain tests, okay, and then only then do we know that this is a contract, okay? So like you're entering the place, you need to check, you need to pass, you have to be tested as COVID free, only then can you enter. So now all agreements are not going to become contracts, need not become contracts, okay? So therefore, you have to see what. So when you apply these tests, one of the things is basically undue influence. Okay, when you're talking about undue influence. So if you take a situation like this, so for instance, if I take if I take Pulkit's, if I enter into an agreement with Pulkit and I say that, okay, Pulkit, you're going to sell me your iPhone for 5,000 rupees. Now, this is a classic case of what Soumya is referring to, that the consideration is not adequate. So what is happening is, this would be covered under undue influence, and this, when Pulkit later on, he agrees to do it because he's afraid of the teacher, okay? So he therefore, he agrees, but then later on he does not sell the phone for 5,000 rupees. So then I sue him, and then the court is going to say this contract is actually vitiated by undue influence. So this is another aspect of what you're saying, Soumya, which is that there is a certain element of check in contract law to ensure that there is no overt kind of bullying going on. Okay, so here they will say, because a teacher-student relationship is not equal. So if I browbeat Pulkit, then he will not want to intimidate to anger the teacher. So he will agree to pretty much whatever I say, and so he agrees to sell it for 5,000 rupees. But obviously that's not the value of the iPhone. Okay, so contract law does have, it's not completely unfair. It does have provisions for that. So we will get to that when we get into section 10. Okay, and you'll see how section 10 basically covers all of chapter 2. All of chapter 2 can be covered. All the sections in chapter 2 are covered basically by section 10. Okay, you start from here, and in the ingredients of this, basically you get the route to go to all of these sections. Okay, so therefore there is a type of, I gave you this example, okay, of a contract with Pulkit, of an agreement with Pulkit. This will not become a contract because this will not be enforceable, because it is vitiated by undue influence. Okay, so once undue influence is shown, once Pulkit is able to demonstrate in the court that this person was my teacher, so obviously I could not just argue with him on an equal footing. So I had to pretty much accept whatever he was saying. And once that is proved, then what will happen is that as you can see in this section, that the court will now say that Ram, you prove that this contract was not vitiated by undue influence. You see, where a person who is going to dominate the will of the other on the face of it, then the burden of proving that such contract was not induced by undue influence shall lie upon the person in a position to dominate the will of the other. So here the teacher will have to prove that this contract is not vitiated by undue influence. So the overall broad answer to your question, Soumya, is that there are two ways to look at the answer to your question, which is that contract law does, look at the second part of the answer first, which is that contract law does have certain basic checks. Okay, so there is a check to ensure that the agreement is not vitiated by undue influence, like the example I gave you now, teacher-student, guru-shishya, other kind of relationship. Okay, so you have to show that it is not vitiated like that. Okay, now that's what. So contract law does have certain checks and balances to ensure that extreme cases of exploitation do not happen. But at the same time, that's why you have free consent and all that. So the idea of free consent is there, but it has to be free consent. Okay, but at the same time, contract law, especially if you look at the culture of the English commercial codes, and you have to be able to see all the connections between the jurisprudential philosophy that goes into adjudicating on commercial disputes. I told you about the English commercial courts and how they have been highly formalistic, and they have just said that, okay, fine, this is your agreement. You agreed to supply soft drinks for the VIPS function at this price. You're an adult. VIPS was not holding a gun to your head. So you signed it. Now you adhere to the contract. Okay, we're not going to get into an analysis of whether this is a fair compensation or not. It's a free market. You tendered for the contract. You got awarded the contract, and now you have to live with it. So there's two sides. They take care that there is no extreme exploitation by having these kind of checks and balances. But after that, they don't get into this kind of a debate too much. because then it will interfere with the flow of commerce, which will happen. What will happen is pretty much every second person is going to start saying that, well, my compensation, I did sign up for this salary, but I think the salary now is not very good. I would like to get a higher salary, and I don't want to do this job and that job because my salary has not been raised. So in this way, if you keep allowing this kind of argument, the normal flow of commerce will be impeded. So you have to also understand how a highly formalistic approach to this adjudicating on commercial disputes, which English courts have maintained for centuries. You have to also see how that has led to the dominance of English law around the world in business matters. Okay, I gave the example in the other class of how a company like Unitech, which is an Indian real estate company, which got into a lot of trouble. I think they were number 2 earlier after DLF. Unitech got into another kind of trouble on the financial derivative contracts. They had done a currency swap, I think, or an interest rate swap with Deutsche Bank. And there was a dispute about that. There were some losses on the contract, which Unitech did not want to pay up. Okay. So the dispute went to the English courts. It went to London, actually. So here's the interesting thing, that Deutsche Bank's a German bank. Sorry, one second. So Unitech is an Indian company. Deutsche Bank is a German bank. But when they signed the contract for the interest rate swap, it was meant to be governed. They agreed to have it governed by English law and to be adjudicated in the courts of London, in the UK courts. Okay. So here, why is this happening? Why are people from all over the world agreeing to have their disputes adjudicated under English law? This is also something to understand. Like I keep asking my students that question which nobody ever asks you in India. Why did these white people come and colonize us? Was it just a coincidence? Why did a bunch of white Westerners come and colonize us? Was it just a coincidence? Why didn't we go and colonize them? Were they doing something in their culture? Were there certain aspects in their culture which made them more effective in certain things like warfare and administration and these kind of things? These are important questions to ask. We have never asked these questions. Okay, so instead we have focused on renaming streets. Okay, if you go to Calcutta, the old historic capital, everything has been renamed. So that's all they did basically, just rename the streets. Never asked the important question as to why did this happen. Okay, so the question is, so you have to also understand this very important point that these things have, international business values these kinds of approaches, a highly formalistic approach, because international businessmen now know that in the English courts, their contracts will be, sort of adjudicated upon in a very formalistic manner. The court will look at the terms of contract. Okay, Soumya, you signed up to deliver soft drinks at this price. Too bad, you don't like it now. You live with it. You signed it. You're an adult. Now you live with it. Okay. They will not listen to your, well, I think it's not adequate now and all that. They're not interested in all that. So you have to understand the value of this also. So there's two sides. Now, is it a little clearer now, Soumya? Answer to your question.
Yes, absolutely. I got it. I just wanted to know if there are some checks to ensure that gross exploitation does not happen.
There
I
are
got it.
checks. But I would definitely tell you in terms of my own opinion about these kinds of debates in the Congress that are happening in the US Congress, and which is on a different matter, mostly on mainly on immigration law. And in the UK, that debate between the Google finance manager and the UK member of parliament, it's totally ridiculous actually, because I mean, here's a legislative branch member saying, are you paying a fair share of tax? Well, if you think he's not paying a fair share, you raise the tax rate. Are you saying that he's not paying the actual tax rate as required? Is he a criminal? Is he breaking the tax law? Then you punish him. So this is a crybaby kind of question actually. Are you paying a fair share of tax? This is a ridiculous, this is a typical political kind of question. And the same thing that happens with the US Congress as well. You see they get all these guys from the immigration enforcement, ICE and border control, customs and border patrol and all these people. These guys are executive branch people, okay? Their job is to enforce the law. If they don't enforce the law, they'll have a problem. So if they enforce the law and then the legislators are saying to them, no, you are so cruel. Well, if you think the law is cruel, you change the law. Okay, so this is all basically, I think it's basically all political posturing actually that happens in many of these parliaments, and I'm sure it happens in our parliament also. So this is all political posturing. You have to understand it for what it is, because the executive branch employees are required to enforce the law. They can't not enforce the law. And if you think the law is unfair, it is the job of the legislature to change the law. Okay, not to make these kind of crybaby posturing arguments in Parliament. So anyway, so this is the total discussion on that. Okay. All right, so that's a new thing that you have introduced into the debate, which is adequacy of consideration. All right, okay. So obviously, it is all these questions are welcome because they all add to the debate. That's why, every course is different, and I always insist on student questions should be answered. We do not have a priority of covering some syllabus. We have only two priorities: that student questions should be answered. If not during the class, at least at the end of the session. And number two, that whatever we cover, that everybody should understand, and that thing should be embedded in your brain forever. These are the only two objectives we have. Okay, so I'm never a fan of the whole syllabus coverage business, because it does not lead to any kind of quality or in-depth learning, because you're just kind of going like a Rajdhani Express trying to cover the syllabus. So, and then what is the level of retention among the students? Okay, that's why our education system, I think, has failed Indian students by not, by failing to remove this kind of focus. Anyway, so adequacy of consideration. All right. So you have understood also that consideration can be much less obvious than me paying money for coffee, okay, or somebody else paying money for the plumber to fix their leaking kitchen sink. Now, there's adequacy of consideration. Now, there's another point here, which is a question of a third party. Okay, so here Harsh had asked this question in the other class about what is this part here about any other person. So we're saying at the desire of the promiser, okay, either the promisee can do something or any other person can do something. Now, this idea is not there in English contract law, funnily enough, in the English common law of contract. But funnily enough, the English wrote this kind of provision into the Indian Contract Act. Okay, so it says that any other person, which means here, what is this any other person? Here it is actually what we call a third party. Okay, by any other person, other than, what is other? Other than promisee or promiser. Okay, so these are the two people who are the parties to the contract. Okay, and there is another person. Other person is basically somebody who is not the promisee or the promiser. So we call them a third party, and we call them a stranger to the contract. Okay, so the contract is generally between two parties. Okay, and you have this concept of stranger to the contract. Okay, so here we have a deal. Well, maybe not. Should not put this as Walmart. Let's put this as neighbor. So, okay. Yes, Soumya.
So can third party be bound by the conditions in the contract?
Yeah, that's what we're saying. In general, no. It's general. The general answer is no. Okay, so we'll come to those. This is what I'm about to discuss right now. Okay, so if you see if the following discussion answers your question, and then you can ask it again. Okay, so in general, the answer is no. Okay, so let's say, so for instance, so when first of all, let's be clear about what is any other person. Here, it is referring to a third party. What is meant by a third party? First, second, and third. First and second, or first and second, two parties to a simple bilateral contract. A third party is person who is not a party to the contract. Okay, so we call him a stranger to the contract. This is the language of the law. So we have to get used to all the terms of art. These are called terms of art, where a particular kind of statement has a specific meaning in a particular context, in a particular domain. Okay, it has a specific meaning. So stranger to the contract is a term of art in the law, which means it's a person who is not a party to the contract. So you could have a deal, for instance, here between, this is an actual case that happened in the UK. I forget the name of this case, but it's, I think, between, the names are the same. It's like Fenwick versus Fenwick kind of a name. Okay, both the names are the same. So there's a case basically where an old man has a deal with his son or his brother, okay, where he makes a deal about some relating to some parts of his inheritance. Okay, so he hands over some part of his property to his son or his brother. Okay, so these are the deal is between these two. Okay, and but also that in the agreement between these two people, there is a provision that a certain amount of money has to be paid to the nephew, okay, of this man. Okay, so this guy, the nephew, is the third party of this contract. The nephew is not a party to this contract, but he is a third party, okay, in the sense that he's not a total stranger to the contract, in the sense that he's not like somebody sitting in DSP, but he is connected to the contract in some way, although he's not officially a party to the contract. But there is a connection because there is some benefit for him under the contract. Okay, so therefore, what happens is that. In this case, this kind of a deal happens, and then what happened was the old man gave up most of his property to his son, and he also put in this term in the contract that the nephew should be given a certain amount of money. But once the old man died, the son didn't give the money to the nephew. So the nephew sued, but then the court applied what is called, it's a very old case in England. The court applied what is called this doctrine. Okay, the doctrine of privity of contract. Okay, so the privity of contract doctrine essentially says privity comes from the word privacy. Privacy here, what we are trying to say is, when we say privity of contract, we are trying to imagine that a contract is like happening inside a room between two parties. So no outsider should go into that room and disturb their privacy. So it's a private aspect of their dealings. And that's why contract law is referred to as a part of public law. As private law, whereas your environmental law will be public law. Okay, whereas here this is private law. Contract law is considered by private law. Sale of goods also, these are all private law because these are between private parties. And so we say, don't disturb the privity of their contract. It's a contract between two parties. And the third party basically is a stranger to the contract. And so in this case, when the nephew comes to sue for his benefit of the contract, the court applies the very strict English doctrine. So the English common law doctrines were generally quite strict. As I told you, they were very formalistic because they wanted to promote certainty, and because of the impact it has on economic activity, economic vitality, business optimism, and all these elements. So English commercial law has historically been highly formalistic, okay, and not getting into too much, as long as they see that there is no obvious injustice, that you're not like forcing getting hold of a minor, holding a gun to a minor's head and forcing him to sign a contract. Unless those kind of things are happening, two consenting adults have signed a contract, and the court is not going to interfere with the terms of their contract. Okay, so this I'll just come up with one more point. I just mention it here, and then I'll once I finish explaining. So the question that Soumya asked is, there is also a very important principle which is called freedom of contract. So your freedom of contract is also related to the idea that Soumya raised. So this is also a sacred principle in commercial law, in a very formal view of commercial law, which actually should really be, now this is my own idea, okay? It should really be called freedom to contract, because it's not freedom of contract. It can be freedom of assembly, but it's not freedom of contract, because it's not the contract which has the freedom. It's the parties who have the freedom. They have the freedom to contract. But unfortunately, what has happened is, like so many things in the law, and in finance everywhere, people have just gotten used to a certain expression. Now people have gotten used to freedom of contract. So even if my criticism is correct, that it actually should be called freedom to contract, nobody's going to use this expression, because this has become so well established that this is what people mean. This is what people say when they mean what I think they should have meant by using this expression. Okay, so what is freedom of contract? I'll just come back to. So it is connected to. Let me just explain it briefly, because it is also connected to privity of contract. So here we say that not only should a third party not come in, third private party not come in, and try to enforce our liabilities on any of the parties to the contract, the official parties, but also the state should not come in. Okay, so the state should not come in. So that brings you the idea of freedom of contract. Okay, freedom of contract is that the state must not interfere. Okay, so what is freedom of contract? Basically, that state should not interfere in the state should not interfere in the terms of privately negotiated contracts. Contracts. Okay. Provided consent is free, etc. Okay, so that you're not holding a gun to somebody's head, or it's not like the example I gave you where I entered into an agreement with Pulkit to sell me his iPhone for 5,000 rupees, which is vitiated by where the consent is not free. It's vitiated by undue influence. Okay. So those not leaving aside those kind of things, the freedom of contract is basically where the state should not talk about state of. So it's a related concept to the privity of contract. The privity of contract is telling other private parties that you have no right to go in and start telling, if two people have entered into a contract, then you have no right to go and tell one of those people that you should do this and that, because you're not a party to the contract. Similarly, in a similar kind of idea, that there is a very important principle of, again, it is all connected to economic policy. Okay, all this ideas, very connected idea, minimum wage, all these kind of things. Freedom of contract basically says that the state must not interfere in the terms of privately negotiated contracts. So which means that, for instance, if I have certain contracts which are, which actually the state does, here you see, the state prohibits agreements by way of wager. Okay, so that means any kind of, typically mostly any agreement that the state considers to be kind of in the nature of gambling, etc. They forbid that in some of these cases, like India, we do that. But in the more intelligent countries where the policy making is much more intelligent, they don't interfere. So we say that if two people have agreed to enter into a contract which looks kind of like a speculative gambling contract, but nobody held a gun to anybody's head. These are free people. They have entered into a contract. If they want to speculate on something, let them do it. And why should the state interfere? Okay, so there's another kind of, so this is actually very strongly connected to your idea of adequacy of consideration. Because again, normally the people who enforce these kinds of ideas, as you can see in the example of the UK Parliament and the US House, etc., US Congress, the people who are trying to interfere in these kind of contract terms are actually the government. Okay, and the government here, the freedom of contract doctrine says that the state should not interfere in the terms of privately negotiated contract. Of course, we have to ensure that there is no kind of criminality going on, etc. So this is another important term that you have to understand, freedom of contract. Generally, you'll find that in the more prosperous countries, economically prosperous countries, you'll find like Singapore, Switzerland, UK also earlier now. I don't know what's happening to the UK now. But generally, Singapore very much true. Switzerland, all these places, the government does not interfere. How did they become prosperous? They became prosperous by following these kind of policies, that the government doesn't interfere needlessly in private contracts. And the government rules very formalistically, judges rule formalistically on contract terms. Okay, so when you have commercial disputes, they get easily resolved. And businessmen want to do deals under English law. This is all these things, benefits flow from these kinds of philosophies. Okay, so coming back to this idea of the stranger to the contract, the third party is a stranger to the contract. So the privity of contract doctrine here, basically what it does, the nephew gets kicked out. Okay, the son does a deal with the dad. When the dad passes away, the son is basically not following the terms of the deal. He's not paying the money to the nephew. Nephew goes to the court. Court tells him, get lost. There's a privity of contract doctrine. You are nobody. You have no rights under this contract. You are a party to the contract. You are a stranger to the contract. Okay, you have no right to sue. Okay, this is the cold, hard, formalistic approach of English common law. Okay, so what happens, as you can see now, this will also some idea to some further elimination to Samya and others who had similar questions. Now, what happens over this? Now, this is although the nephew was entitled to get certain benefits, but he's not able to sue under the old English common law doctrines. Now, what happens? Common law, as you know, is the judgments of judges. Okay, all the pronouncements of judges over the years, the body of those, the collection of judgments. That's common law. There is no statute law there. Okay, it is statute law, the Indian Contract Act, Transfer of Property Act, Income Tax Act. There's no statute law in the pure form of the common law. So what happened is that the society felt that this was not fair. People like the nephew should get their money. And so eventually the English Parliament, and you can see once again that the British Parliament actually, that the separation of powers principles are being adhered to, that the judges do not do anything. You see how the formalist approach of English courts is consistent with the separation of powers. They don't interfere. Okay, they say this is our doctrine. Okay, privity of contract, and we will not allow this guy to enforce the sue for the benefits under the contract. But the UK Parliament felt that this was the legislature felt that this is not fair. These guys who are beneficiaries of under the contract, they should have a right to sue. So eventually the parliament, this is how society should function in a constitutional democracy. It's not the job of the judge to, make the law from the bench. The parliament decides that this is a social injustice, and they come up with this new law called, I'm not sure it's exactly that, there's something like that. This is basically the language of the Contracts Rights of Third Parties Act. Okay, so what it does basically is that it gives rights to third parties who are beneficiaries, okay, under the contract terms, so they can sue. In this case, if this thing had been this nephew case, this is actually an actual case. It was a very old case. At that time, this act was not in force. It had not been passed. Okay, so it is cases like this that kept on happening, and then the parliament felt that this is very unfair, so they came out with this law. And they gave these kind of people, so if this guy had been alive when this was passed, then he would have been able to sue. Okay, but they have the right now. So once again, you can see the connection. This is a substantive law because substantive laws define rights and liabilities. So substantive law invests the rights in the third parties to sue. Okay. Therefore, they're beneficiaries. Okay, one more thing I'll just point out here. Please note the use of the word per. You note that I am not saying as per. In India, pretty much everybody writes, even highly educated people write as per. This is actually wrong. Because as is superfluous. A per means, a Latin expression means according to. If you read something written by Englishmen or Australians or Canadians or British or Americans, you will find they do not write as per. Okay, they write per because most of them have studied Latin, and per means according to. So if you write as per means as according to, which doesn't make any sense. Okay, but unfortunately, the situation in India is so bad that if you don't write per, people will cut marks and say you should have written as per. Okay, but please explain to them next time that this as per is superfluous. All right. So this is another thing which is I thought I'd just highlight, because in lab you're supposed to learn many things. You're supposed to be able to have discussions on economic policy, which are some of the most important discussions. Okay, but that's what affects all our lives. Then you have discussions on legal matters, but also you try to improve your written English and your English comprehension, etc. Okay, and your logical thinking, all these other elements. Okay, so this is one little nitpicking point that I wanted to make. Okay, so the British Parliament introduces this, and on the question of nitpicking points, let me make one more point here, which is coming here. Or let's just look at this. We don't have to go back. We don't have to go further down in our. This is contract rights of third parties. Okay, let me just point one more nitpicking point here. That I've made this observation in your notes. I just don't want to go back all the way there. Okay, remember this one, section 2 This actually has called interpretation clause. Now, I will say that this statement is not correct. They should have been called, so on. Section 2D is consideration. Okay, this is what you have, section 2D. It should not have been called clause, it should have been called clauses, because there are more than these are the clauses. Okay, so in the law, when we refer to these, we call this a section. So we say section 2, clause D, section 2, clause C. So is there only one clause here? No, there are many clauses. So it should have been interpretation clauses. Even better, it should have been just interpretation section or something like that. Okay, or you could have just called it interpretation. But certainly calling it interpretation clause is not correct. But again, this is stuck. You pretty much go into any legislation, I'm pretty sure you go into Transfer of Property Act, same kind of criticism will apply. All right, so but that I just wanted to point that out in terms of, because the objective here is to make you think in a very, very precise manner, and also to make you very particular about
Hello,
yeah, yeah,
sir.
yeah.
Could you please repeat the last few lines? Your voice was breaking.
Okay. Interpretation clause. You saw the fact that I pointed out that there are many clauses here. You saw that, Sheena?
Yes, sir.
Yeah. So I was saying that there are many clauses here. It is not correct to call it interpretation clause, because these are the clauses. So this should have been called interpretation clauses, or it should have been called the interpretation section, which is section 2. Or it could have been called just simply interpretation of terms or something like that, or definitions or something like that. Okay, but this interpretation clause term is technically incorrect. Okay, and the reason I'm pointing it out is because I want to train you to think like this and see things like this, to be highly particular. If even an S is missing, you should notice it. Okay, if there is a comma, full stop, which should have been there, is not there, you should notice it. So it is important to be very, very particular in the use of language, because you are not like hanging out with your friends on a weekend going for a movie. Then you can be relaxed in the way you use language. But if you're in a business context, in a business school, discussing a point or having any kind of debate about the economy or business matters, you have to be highly specific, highly particular about the use of language. Okay, this is the kind of thinking that I want to inculcate in the students. So that's why I'm pointing this out. Okay, so nobody really bothered about these kind of things, but I think that people should be. I think the students should be trained to be bothered about even these kind of small things. Okay, so this is something on the point of, because I was saying that I was making this nitpicking kind of comment about as per, so I thought I'll make another nitpicking kind of comment about interpretation clause. Okay, now here what we have is, so you have this development of the UK Rights of Third Parties Act. Okay, UK Contract Rights of Third Parties Act, which you know what it does. Okay, now this idea of stranger to the contract, okay, is basically talking about the privity of contract. The party is not a party to the contract. Then on this doctrine, actually, I'll just briefly explain one famous case, okay, which you should be aware of. It is basically a Dunlop versus Selfridge, okay, where what happened was, Dunlop, as you know, is a tire maker. Selfridge is a department store, okay. So these guys have sold. These guys, what they did was these are obviously like manufacturers. They have been selling tires to a wholesaler dealer kind of thing, and then the dealer has sold it onwards to Selfridge, the department store. This is a retail interface. Okay? This is how business works. You have manufacturer, you have wholesale dealer, and then wholesale dealer sells to the retail outlet, which is Selfridge. Now, when Dunlop sold the tires to the wholesale dealers, they had a term in their contract which said that you cannot discount these tires. Either you can't discount or you can't discount beyond a certain X percentage. Okay, so this was the contract between Dunlop and the dealers. Now, eventually the dealers sold these tires to Selfridge. Okay, now they have a separate contract between the dealers and Selfridge, where Dunlop is not involved. Now, eventually what Selfridge did was, and this one did not have any kind of a discount prohibition kind of clause. So Selfridge started discounting the tires because I guess they were not moving, inventory was not moving, so they started discounting. And then Dunlop came and sued Selfridge and said that you are not allowed to discount because we have a deal with the dealers that you're not supposed to discount. So Selfridge basically told Dunlop to get lost because of the privity of contract. So Selfridge said, my contract is with the dealer, who the hell are you? Okay, so the court upheld Selfridge's position. Because the court is also very formalistic, it will say privity of contract applies. You cannot sue, you are not a party to the contract between the dealers and Selfridge, so you have no right to sue Selfridge. Okay, so this is basically the story in this contract. So it's a well-known case in the case when illustrating what is meant by privity of contract. Okay, now coming to this, what we are saying is that what this point, we'll see how it actually happens in greater detail, but I just wanted to give you an idea, okay, to develop the point that the question that Harsh had raised in the other class. That who's this any other person? Give me some examples, okay? Now here, in the Old English case, the nephew is the example of any other person. Okay, he's a stranger to the contract, and actually, it is possible to show that under certain assumptions that he actually is. He did do something under the contract, or there was something that he suffered, some kind of detriment or sacrifice. So in this case, what we are trying to say is that when you bring in this kind of, where have I written this? There is a part where I have written that, yeah. So when we say, when in section 2D, when we say that at the desire of the promisor, the promisee or any other person, okay, when we introduce this other term, what we are doing is we are creating a possibility that although this other person is a stranger to the contract, okay, which is the more commonly used term, he might not be a stranger to the consideration. In the sense that whatever something that he does might form the consideration for the promise here, okay, and that will seek to bind this party, so that what will happen is, even though this guy is not a party to the contract, because the ICA 2D section 2D says at the desire of the promisor, the promisee might do something, or any other person might do something. So if any other person does something, and if we can show that the nephew in this case, for instance, actually did something in the sense of suffering some kind of detriment, okay, if that happened, if we can show that, then we can actually we can see clearly that this is creating a possibility that although you may be a stranger to the contract, clearly you are, because you are being called any other person. That means you're a third party. You're obvious, the moment you're a third party, you're a stranger to the contract. But you may still have a right to sue because you might not be a stranger to the consideration. Okay, so generally when this rule was evolved, okay, this rule of privity of contract, okay, and the way it was applied to Dunlop and it was applied to the nephew, okay, the implicit assumption here is that, okay, that, let's put this clear here, that, so there are many complicated ideas we're discussing here. Please make sure you understand this. Re-listen to the, okay, now you can't listen to the video, now it has been banned. So now what we do is you have to listen, read the notes and try to remember what we discussed, okay? And I'll try to make the notes much clearer, and I'm generally putting everything in there. Okay, so when, what was I going to say here? I got a little confused now. Yeah, okay. So when, now here I'm not writing perfect English, it should be the privity of contract doctrine, okay? When the privity of contract doctrine is used to deny parties like this nephew, okay, and Dunlop, okay, nephew, Dunlop, etc. Okay, there's an implicit assumption. Okay, so some of you might have problems with the English and all that I'm using. Maybe I'm using complex sentences, but this is part of your training as an MBA student. You have to improve your comprehension. Okay, there's an implicit assumption that these denied parties, not good English, but I want to indicate nephew and Dunlop, these denied parties were also a stranger to the consideration. Okay, that means no consideration flowed from these people, and therefore they could not possibly be allowed to sue. Okay, this is what is implicit in the privity of contract doctrine being used to deny people like the nephew and Dunlop. There is an implicit assumption that because you're not a party to the contract, therefore no consideration flowed from you. But the peculiar language of Section 2D of the Indian Contract Act creates a possibility that you may actually be a third party, but you may be providing the consideration for the promise. If you see the full language, consideration for the promise. Okay, such so and so is for consideration for the promise. What is it? It's called a consideration for the promise. For which promise? This promise made by this guy. Following which promise, he then expresses a desire to either this guy or this guy, that please do this for me. Do this specifically which I want. I want this, and I want you or you to do this. So if this guy does it, then he has provided consideration for the promise, and he will have a right to sue, even under the common law. So basically the idea is, I want to make sure I'm not over the time. Okay, so you understand, I hope you understand what I'm saying here. These are all very complicated concepts. Okay, so that's why I would have liked to have the video available. But anyway, so so you understand what is being. I think in the notes, if you remember what is being done, I put everything into the notes. Okay. So this is the idea. So that when you have these complicated ideas that this privity of contract doctrine was being applied to deny people like Dunlop, there is an implicit assumption that because they are a stranger to the contract, they are also a stranger to the consideration. But clearly Section 2D has thought of certain scenarios where this might not be true. They may be a stranger to the contract, being this party, but they may still provide consideration for the promise. Okay, so this is important to learn. Making of a counter offer, not acceptance of offer. So quickly, let me just finish this. Okay, so if Ritika says, sir, I'll sell you my scooty for 15,000 rupees, and I say, okay, agreed, but I'll pay only 10,000 rupees. That's not an acceptance of Ritika's offer. That's a counter offer that I'm making. Okay, so this language actually has to go up to the point of, I just wanted to explain this line. This has to actually go up to the point where we talk about offer and acceptance in the Sale of Goods Act. Okay, so please understand this one point. And I think we are almost there. Our alarm will go off anytime. This I think I have already put into the top part, which is where we go to sale of goods. Yeah, making of an acceptance. So Ritika says, buy my scooty for 15,000. I say, yes, I buy it, but for 10,000. That's not acceptance of an offer. That's making of a counter offer. That cannot be considered. So there's no contract right now. This contract will only happen if now Ritika agrees to my offer, counter offer, and says, okay, sir, I'll sell it to you for 10,000. Now you have a contract. Okay. So maybe I forgot to set the alarm. Okay, I'm very particular about this because I don't want to detain the students. Yeah, I forgot to set the alarm. We're 1 minute over. Okay, so all right, so class is dismissed, folks. And if anybody has a question, then we can look at it. You guys, otherwise, you can go home, enjoy yourself, go to Starbucks and pay some consideration, have a coffee or whatever. Okay, all right. Anybody have any questions at this stage? Okay, all right. So
Yes, sir.
yeah, you have a question, Soumya?
So I have a question. Yes, sir. So,
Yeah.
sir, are we saying that in Indian Contract Act, the third party can sue?
Yeah. So first you have to say sue, not sue. Okay.
Sue, yes.
Sue is like the knitting and all that. Okay. So here the third party can sue, but not always. Remember, it has to be that the party has provided consideration. Okay. Whereas, let's go down further. It has to be that the party has provided consideration, right? So yeah. Any other person has done something, okay? 3 tenses. Any other person, that means third party, has done something. What is that something? It is consideration for the promise. For which promise? For this guy's promise. So if this third party, stranger to the contract, has done something and provided consideration for his promise, then he is bound under the law of consideration to honor the agreement, okay, which is sealed in this manner. And so that means here this would be a case where this person, although he's a third party and a stranger to the contract, he is nevertheless not a stranger to the consideration, and he shall have a right to sue. But so answer to your question is yes, only if he has provided the consideration for the promise. Is this clear? Navya?
Yes, sir.
Okay,
Yes,
once
sir.
you do the
Thank
case, you understand. And this is exactly what I've written here. Okay, so it's a complex discussion, but consideration is a very important topic in contract law, and very subtle topic. As you can see, so many elements came into our discussion. Okay, so what I'm saying here is, when at the desire of the promisor, what Section 2D's language is saying is, it's creating a possibility that the stranger to the contract, this guy, definitely stranger to a contract, because he's not this or this, but he might nevertheless not be a stranger to the consideration, because he did something which was the consideration for the promise made by this guy. So he shall have a right to sue. Okay, only under these circumstances. So it's a very interesting type of language, and you can see in this, see how rich the topic is. And the last point, which I forgot to mention, I'll just mention it again next time, is that agreements without consideration can't be enforced. Okay, that's why we spend so much time on consideration. Okay, so you can see how many topics we have discussed in this little lecture on consideration. We have discussed the general language of the Contract Act. We have discussed, okay, what is the market? How do you define a market where venue for exchanging goods and services for money? We talked about obvious consideration, less obvious consideration. We talked about freedom of contract, adequacy of consideration. What is the meaning of any other person? Okay. Then stranger to the contract, privity of contract, famous cases, then privity of stranger to the consideration, okay, this implicit assumption, and then we talked about this last part where it basically creates this possibility. Okay, so we had a rich discussion, okay, and hopefully we'll continue in this manner. So you can see, yes, we are not covering that much ground, but as I said, that's never the focus. The focus is to have a good discussion and to permanently embed everything that is discussed in your brains. That's basically all we care about. Okay, all right. Any other questions, Soumya? Or anybody else?
No, sir. Thank you.
Okay, all right. Take care. So I'll stop the sharing and I'll stop the recording. And so please remember, folks, the videos are not going to go on now, okay? Until Sajif sir or somebody gives a contrary indication. So I will not be able to share the video. So I'll share the first 7 videos. Okay? Just give me a few days. All right. Okay, take care. I'll see you guys later. Next time.